Uh, Good afternoon, everybody. I'm really excited to give you this talk today about ethics for litigating in the post-pandemic world. I'm hoping that you'll gain some insights about how the landscape of litigation has changed since the onset of the pandemic and some tips for how to avoid ethics pitfalls that might unwittingly befall you as we litigate in this new world. Just to introduce myself, my name is Kenneth Trujillo Jameson, and I'm a senior associate at Willenkin LLP. We're a litigation boutique based out of Los Angeles, but with a national practice. We specialize in complex business litigation of a variety of sorts. My personal practice focuses in particular on copyright disputes and complex commercial disputes. And in particular, I litigated, along with my colleagues, a case in the entirety of litigation, basically from soup to nuts. And part of what I want to share with you today are some of the insights that I gained from that experience. So just to kind of orient you for what I'd like to talk about today, first I want to kind of contextualize, sort of give kind of a recap of how we've gotten to this point, and at least what seems like is going to be the future for litigation, at least for the foreseeable future, as we sort of navigate through the end of the beginning of the pandemic. And then I want to focus on three aspects of litigation that I think present some interesting ethical issues in the remote world. One being remote depositions, the next being remote hearings and trials, and then the third being attorneys working remotely. And then at the end, I'd like to take some questions. But throughout the presentation, I want to try to make this as interactive as possible. So I would encourage you to use the chat function. If you have questions, if they come to mind, drop them in the chat and I'll try to get to them before the end of the presentation. There's also going to be some instances where I'm actually going to ask for audience participation to provide some responses to some questions I'd like to pose to you. And so if you could, I'd appreciate you using the chat function to do that. So first, what happened during the pandemic? This is not news to you all. Because of the pandemic, courthouses across the country initially closed. And then many of them, when they did reopen with very limited in-person proceedings. And so, for example, at the United States Supreme Court, at the top of the legal food chain, they went to entirely online oral arguments since April of 2020, and they have continued that to this day. And at least as of when I'm giving this presentation, they haven't given any indication that that will change anytime soon. Likewise, courts of appeals like the Ninth Circuit have been holding online oral arguments. And even in the state and federal trial courts, they've reopened to limited in-person proceedings and have instituted very strict coronavirus protocols, physical distancing, plexiglass, things of that sort, so that when there are in-person proceedings, they just don't look like the classic Law and Order setting that we might be familiar with that was before the pandemic. And so that's what's been happening in the courts. But as we all know, for our clients and also for law firms, our work changed from being predominantly in person to being almost exclusively remote, literally overnight. And so that's the world we've been experiencing for the last year to year and a half. And even as we're at the stage where we're starting to at least move past the initial emergency stage of the pandemic, there's still most of us that are still working remote. Now, what's happening now and what looks like it's going to be happening in the future? So courts have started to reopen, but sort of taking baby steps in doing so. So for example, just using the California federal courts, the courts have reopened, and for example, the Northern District of California reopened at the beginning of July, although there still are coronavirus protocols in place. And judges still have significant discretion to hold certain kinds of proceedings and hearings remotely. And then when you're talking about, what's going on with clients and with firms, the attorneys who are litigating, that's sort of running the gamut as well. You have companies like Morgan Stanley, for example, who last month announced that they had a real strong emphasis in trying to get their workers to come back in person. But then we also see companies like Google, a lot of law firms in the big law context that have implemented hybrid policies that they plan to implement this fall. And then you also have certain firms that are actually hiring associates that the intent is that they would be entirely remote. And so we have a new world a new normal we're returning to, in which hybrid work seems to be an ever-present part of legal practice. And that's going to impact how we litigate as well. It has been, and I think some of those things, those innovations or accommodations that have happened during the pandemic look like they're going to stand the test of time. Now, first I want to focus on remote depositions. That's an accommodation that started during the pandemic as people were unable to travel or to be in person for depositions. And before the pandemic, these were a rare occurrence. Now they're very common. And the question that I wanted to discuss with you is, when you're going to do remote depositions, to make sure you're not stepping on any ethical tax that would really trip you up as you navigate from doing a deposition from an in-person setting to the remote setting. Now, why will this continue? One issue is cost. It's a lot cheaper to do a deposition when the lawyers are not traveling and having to pay for hotel fees, so that can be attractive for clients. The cost involved in doing a deposition is lower. It's also more convenient. The witnesses can take the deposition from their home or perhaps an office in their company's building, as opposed to having to travel to an unfamiliar law firm setting to take the deposition. So that's more convenient for the witnesses. And it's also more convenient for the lawyers. The lawyers can take a deposition in the morning and then move on to work in the afternoon. And so I think there probably will still be some instances of in-person depositions going forward, but I think remote depositions as part of the discovery process is probably going to stay for at least the foreseeable future. Now, what are some of the rules that come into play when you're talking about a remote deposition? One is ABA Model Rule 1.1, and that provides that a lawyer shall provide competent representation to a client. And competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Comment 8 to that rule emphasizes that to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. And so with this one, it's important, it's an ethical obligation that as litigation practice moves to a remote setting, that as a lawyer, you're both adept with the new technology that's relevant to doing a deposition in that context, and are familiar with the risks and roadblocks that can come into play with a deposition in that setting. Also, if you are a supervising attorney and you are working with junior attorneys or staff in doing a deposition, ABA Model Rule 5.1b can come into play. And that one provides that a lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules of professional conduct. And so it's not only incumbent upon you as the lawyer to be familiar with the ethical rules of a remote deposition, but also to make sure that everyone on the team that you supervise is familiar as well. Now, to illustrate this, I wanted to use sort of a vignette, if you will. And this is the part where I'm sort of welcoming participation from those in the audience. So I want you to imagine you're meeting Amy, who's a litigation partner at a top firm. She's a great attorney, but she's just not very familiar with some of the new technology for depositions that was made available during the pandemic. So she entrusted her technology savvy associate, Ray, to help out with that. So she's going to be doing a deposition, and she arranged for Ray to handle the logistics for the deposition. Now, Ray is familiar with Zoom and that you can use the record feature on Zoom. So instead of getting a videographer, he decides he's just going to use the record feature for the Zoom. And Amy, the partner, doesn't object. Now, I want to ask you, are there any trips or roadblocks that you see in how Ray has arranged for the logistics for this deposition? And if you have feedback, feel free to drop it in the chat. So some people have mentioned that, for one, that the rules requiring a certified videographer didn't change just because of the pandemic, and that there could be an issue that Zoom recordings are admissible. And that's right on point. And this actually is an issue that came up in a case out of the Northern District of Illinois last year. In that case, like the vignette, the attorney used a Zoom recording, but they had a certified stenographer for the deposition, but the stenographer refused to certify the video recording. And then when it came to trying to get that recording admissible evidence, the court declined to do so. The court pointed to Rule 30F of the Rules of Civil Procedure, which provides that the officer, the one videotaping the deposition, must certify that the witness was duly sworn and that the deposition accurately records the witness's testimony. The court went on to note that those rules are designed to ensure that a neutral individual administers the oath and that the deposition is an accurate reflection of the witness's testimony. It removes doubt as to whether a recording or transcript has been tampered with or edited by either party, and the process also maintains the integrity of the deposition, which can involve managing changes to the transcript, custody of the deposition materials, and appearances on video. And the court noted that before COVID, the unbalanced courts have held against the admissibility of a party counsel's video recording of a deposition, and that doesn't change merely because we're in the COVID context. So this is one sort of thing that can trip you up. If you're going to do a deposition recording, make sure you're still working with an established videographer, an established court reporter service that's going to provide and follow the procedural rules that are required for the deposition. Don't get distracted by that and use the technology without thinking through whether that technology is going to comport with the procedural requirements. And in this particular context, Amy as the partner probably should have alerted Ray to that fact, given her duty to supervise, and made sure that Ray, if he was going to do that, that's not the way that he wants to go, he should make sure that he gets a certified videographer to play that role. Now, one other issue that comes into play is confidentiality, and that's particularly key because when you're in a remote deposition setting, you're going to have information that's going to be accessible through the internet. Now, if you were in an in-person deposition, this stuff would ordinarily be handled via paper in the room, but because we're going to be doing remote depositions, you need to make sure that you're taking the proper precautions to preserve confidentiality when you're disseminating information electronically and it's available online. So first, you have ABA Model Rule 1.6c, which provides that lawyers must make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. And comment 18 to that rule, emphasizes again that the rule requires a lawyer to act competently to safeguard information relating to the representation of a client against unauthorized access by third parties and against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in the representation of the client or who are subject to the lawyer's supervision. And comment 19 to that rule provides that lawyers must take reasonable precautions when transmitting communications that contain information related to a client's representation. And so, this is actually really incumbent, especially in the remote deposition context, because as you may know, law firms are in particular targets for cyber criminals because law firms are likely to have concentrated amounts of confidential, potentially lucrative information. And as we know as litigators, in a case, usually the most key of that information is likely to be discussed or asked questions about at a deposition. So those deposition exhibits are critical to the deposition, but they're also critical or a right target for cyber criminals. So you want to make sure that you're not disseminating information in a way that's going to implicate confidentiality. So let's go back to our cautionary tale, and I'll again ask for insights from the audience for some of the ethical issues that might be presented here. So during the deposition, Amy is using online documents as exhibits, and Ray uploaded those documents to his personal Dropbox account with the password of ABC123. And then, so when Ray decided to send the exhibits to opposing counsel or make them accessible, he emailed opposing counsel with the link to the Dropbox folder, but the same email that he sent, the link also contained the password. Does anyone see any ethical issues that might be present in this scenario? And feel free to drop them in the chat. So some point out that for one, it's really curious that Ray is using his personal Dropbox account. Why is he using the personal Dropbox account? That's a really clear one. There's a possibility that when you're uploading documents to a personal Dropbox folder, you might actually be inadvertently breaking privilege by transmitting information to an unaffiliated third party. And so in a deposition context, depending on your deposition vendor, they may have their own online resource to upload documents to. If they do, you should make sure to take steps that you're familiar with and are comfortable with the security that they're using to protect those documents, but you don't want to use your personal Dropbox account to try to disseminate that information, okay? And then secondly, the password that you see here is definitely not secure. ABC123 is the beginning of a famous Jackson 5 song, but it shouldn't be your password. There are websites that you can use that can create strong passwords that have the features like uppercase and lowercase letters, special characters, things that we're familiar with from other online websites. But you want to make sure that the password you're using for documents as important as a deposition exhibit isn't protected by a password as plain as this. And then, and this is something that I think can be easy to do, but if you're going to send the password to opposing counsel to gain access to documents, you want to make sure that you're going to send the password by separate email. And when you're sending a separate email, you also want to take precautions that you're not, forwarding that first email, sending the link, and then adding the password to it, so it's still in the same email chain. You should probably create a separate email with the password so that they're not connected in the same document. Moving on a little bit in the example here, Rob, who's the counsel for the witness, did not take time to arrange for a quiet, confidential place where the witness could be deposed. And so the witness just went to a nearby Starbucks. And then halfway through the deposition, the witness's AirPods ran out of battery. And so the witness took the remainder of the deposition without using headphones, using the speaker on his laptop. Does anyone see any problems here with how this deposition is proceeding? Privacy issues that are present here in the deposition. You also have the background noise from the Starbucks that's likely to disrupt the deposition. And you also have the issue that the information that he's been discussing may be breaking privilege because other people can overhear that. And those are obviously key things here. One thing I wanted to focus on is, the Starbucks example is a pretty obvious one. No one would likely want to take a deposition at Starbucks. But in a remote deposition, I think you should give some careful consideration to where the witness is going to be for the deposition. The witness, could be at home for the deposition, but there are the issues of background noise and distractions that could take place there. And I would suspect, we're still in the pandemic, but I would suspect that as things go on, courts are going to be less and less forgiving about these kinds of issues as we move into the world where people can return to the office safely to engage in certain kinds of activities. And if they're going to be taking the deposition from their workplace, you want to make sure they're not taking the deposition at a cubicle or in a conference room where others may still overhear the content of the deposition. That may be secure in that it's not at a Starbucks, but there may be protective orders or other rules in place that carefully circumscribe who on the business side of your client should get access to confidential and or highly confidential information. And so if you're going to be doing the deposition remotely and it's in your client's office, it's at your office, you want to make sure that wherever that is, it's quiet. It's not going to be someplace where others can eavesdrop and overhear what's going on, or just see what's going on the witness's computer. I think it's the type of thing where foresight will avoid pitfalls that can come up with that, and hopefully avoid inadvertent disclosure of confidential and privileged information to those who are not supposed to get it. And then continuing on with this vignette, the witness was testifying as a corporate representative. And during the deposition, it became obvious that the witness was reading his answers from a document that was in front of him. And Amy asked Rob, the witness's counsel, to send her a copy of the document, but Rob refused to do so until the very end of the deposition. Does anyone see any ethical issues that may be present from this part of the case? Well, one thing I'll notice is that, this particular scenario in terms of the witness having the documents in a corporate representative capacity, this came up recently in a case involving the Exxon Corporation, and it actually led to the resignation of the newly appointed director of enforcement for the SEC. So this is the type of situation that can really get you into hot water. So in that case, it's called Doe 1 versus Exxon Mobil Corp, and the decision came out in May of this year. Exxon had a witness who was testifying in a 30v6 capacity. And during the deposition, it became obvious that he had a document that had carefully prepared notes that seemed to be what he was reading verbatim in response to the questions at the deposition. Doe's attorney asked to get the document, and Exxon's lawyers refused to provide it until the very end of the deposition. And ultimately, Doe's lawyers then moved for sanctions against Exxon's attorneys and against Exxon for not only not answering a bunch of questions during the deposition, but also in the way that they handled this document. And ultimately, the court sanctioned Exxon because they hadn't provided that information during the deposition or until the end of the deposition. And there was a deposition protocol in place that limited the documents that witnesses could have available to them to just the documents that were either exhibits in the case or had been already disclosed. And this is something that I think is of heightened importance in the remote world, where your witnesses may be taking the deposition from the computer that they use for work. Whether they're testifying in their individual capacity or in a corporate capacity, they may be tempted because the documents are there at their literal fingertips to try to access a document to get them the answer that they just don't remember at the time when the question is being asked. And that can lead to a lot of mischief because that's going to require turning over those documents. That may lead to investigation of the sources that they're looking for on those computers for those documents. That could lead to some discovery mischief because of that. But also it's the type of temptation that just isn't really present in the pre-pandemic world when the deposition is ordinarily in person and those documents just aren't there. So it's important that not only if your witness is going to have some document you are going to allow them to see, that you turn that over, but it's also important to make sure your witnesses are cognizant that if they try to access their computer during a deposition to find information, that would need to get turned over. And then also if they have other documents that they seem that they're looking above the computer screen, they're looking to the side, that might prompt questions from the opposing counsel to get those documents. And so you want to make sure your witnesses who aren't going to be there present with you are aware of that and are not going to unnecessarily cause you to have to turn over stuff you don't want to turn over because of that concern. So just a few practice tips in this area. First, you want to make sure you learn the technology you will use for depositions. I think at this stage of the pandemic, we're all familiar with Zoom. However, during the depositions, depending on your deposition vendor, there may be other technologies, websites, screen share, things of that sort that might come up into play in a deposition. Make sure you're familiar with how to do that. Secondly, you want to make sure you're taking steps to ensure the security of online deposition exhibits, making sure you're using a secure location for them and using strong passwords to protect against unauthorized access to those documents. And then during the deposition, make sure that your witnesses are not trying to access documents on their computer during the deposition. That's just something that is an issue that wouldn't come up before, but something you want to be mindful of that you are prepared for during the deposition. Now I want to move on to the remote hearings and trials context. And I think we're all familiar with some of the obvious mistakes that some of our colleagues in the profession have made during the pandemic. There's the example here of the cat lawyer who proclaimed he was not a cat to the judge. There's also another example of a party in a case who had a very colorful expletive as his Zoom name, and he narrowly escaped being held in contempt for the use of that profane name in his Zoom account. Those are some obvious things, and I'm going to assume that at this stage of the pandemic, we're familiar with some of those issues that come into play. But I want to sort of focus on, if you're going to do remote hearings, the ethical things that come into play, and also some of the tips for making sure that you're going to be advocating for your client in the best way you can, using the technology that's available to you because it's remote. So some applicable ethical rules, we have the ABA Model Rule 1.1 that we discussed earlier, the rule about competence. We also have the rule of diligence, ABA Model Rule 1.3, that provides that a lawyer shall act with reasonable diligence and promptness in representing a client. And in looking at some of the ABA formal opinions, I think this encompasses, this rule of diligence encompasses the need to make sure that if you're going to be advocating for your client in a remote setting, that you're doing so in a way that's really putting your client's best foot forward and is consistent with the ethical obligations you would have if you were doing that presentation in person. So going back to our vignette, Amy has a post-trial closing argument coming up, but a recent surge in COVID-19 cases in the area where the court is caused the judge in her case to hold the argument by Zoom rather than in person. But Amy prefers not to commute to her office for the hearing, and so she presented the argument from her home office. Does anyone see any issues that might come into play here for doing this presentation from your home versus going into the office to do it? So someone has mentioned one is background noise, another is potential internet issues without tech support. I think both of those are key. I think obviously during the pandemic, courts had to accommodate some of these issues and recognize that they were sort of unavoidable when we're all working from home and there's no option to go into the office. Again, my prediction is that as we move back into the post or this new world, courts are going to be less forgiving of those mistakes if they know that you could just go into, or they think you could just go into your office to do that hearing. So you want to, I think that the best advice would be, if you can, try to do this presentation from your home, from your actual office, to try to do so, and to try to have a setup there that's prepared for doing so. I think it avoids some of the background noise issues and potentially some of the internet issues that may come up. Moving forward, Amy at the deposition uses her computer camera and the microphone, but she's too close to the computer, and so the camera zoomed in too close, and also her microphone is poor, and so the judge repeatedly asks her to speak up. Anyone see? I think the issues here may be fairly obvious. I think in terms of making a professional presentation to the court, at this stage, some of the learning curve of Zoom and the like from early in the pandemic, I think, has gone behind us. And so the fact that she is distracting or potentially distracting from her presentation from being too close to the camera, and the fact that the judge can't hear her, these are simple things that you can address through purchasing a built-in, purchasing an actual webcam, purchasing an actual microphone that connects to your lapel or your blouse or whatever, your dress, whatever it is, it's going to make sure it has a closer sound for the microphone, you don't want to have the judge being annoyed because he can't hear you and all he's really seeing is half of your head. Moving on, Amy prepared a PowerPoint slide for the argument, but she doesn't know how to use the screen share function on Zoom, and so she's unable to use it. Here, I think, again, you're seeing that this is detracting from her ability to deliver a persuasive presentation to the court. And it's something that I think is even more incumbent in the virtual world, because unlike in the courtroom, where you might be able to use the volume of your voice, your presence to move around in order to maintain the attention of the judge, it's really critical for you to do what you can via the remote setting to make sure that the judge is really paying attention to your argument. And attractive, interesting visuals can be an even more important part of that than if you were in the courtroom. So the fact that she had a PowerPoint slide deck that could have been an excellent way to guide the court in hearing her argument, the fact that she didn't know how to present it via the technology, that's something that's really going to be a strong impediment to her ability to persuade the court and to keep the court's attention. The court, him or herself, may also be in a location where they may be distracted by things around them. And so you want to do whatever you can to try to maintain the attention of the court. And being able to use the technology properly is one part of that. And going on to the rest of the tale, and this was mentioned earlier, midway through the argument, the internet to Amy's house went off, and she doesn't have a personal hotspot or doesn't know how to use that feature on her phone. And so she was unable to reconnect to the courtroom for the hearing. And here I just want to emphasize that if you're going to do a proceeding like this from home or not from your office, or even in the office, you want to take precautions to make sure you have a backup if the internet goes out. If you have an iPhone or a smartphone, there's usually a way to do that from your phone. There are also products that you can get from cellular providers that have a backup connection, but it's important to have that. And I'll use an example, not particularly from the legal context, but at a presentation for an organization that I'm involved in. 5 minutes before that presentation, the MC, the internet at his house went out. Luckily, he had a backup, so he was able to connect through that backup device and was able to go ahead and proceed with the presentation. But had he not, it would have been a very disastrous presentation simply because of the internet. So you want to make sure that you have that backup ready in case you need to use it, so that instead of it being you can't get back to the courtroom at all, you have a quick way to try to get back to the courtroom, apologize to the court, and then proceed with your presentation. So with some suggestions here, one, you should prepare what I would call a virtual counsel table in your office. Your firm office may be ideal, and you can think about having a dedicated setup where there's a camera, microphone, perhaps a table, a podium. There's a place in your office where you have it set up so that when you need to do a remote hearing, you're already ready to go. You have the connectivity there, and you're able to proceed. If not, or if you have to take the hearing from home, make sure you get a good camera and a microphone to make sure that you're going to be seen and heard properly by the court. And you should also consider doing a video and a sound check beforehand to make sure that the court can see and hear you properly. Secondly, and again, it goes to technology. If you're going to use a demonstrative, like a PowerPoint, practice using the technology before the argument. And one thing to highlight here is that certain courts may use different technology. Some may use Zoom, some may use something else. So before whatever your hearing is, you want to make sure to figure out what that technology is, download it onto your computer, and practice using it if you can before you actually get in front of the court. And then lastly, get a backup internet source in case the internet goes out and you're not able to get back to the courtroom through your original connection. All right, lastly, I want to talk about attorneys working remotely. And why is this going to be an issue? As we all know, remote or hybrid work is definitely here to stay. And given what's happened during the pandemic, there are certain lawyers who have relocated entirely and permanently to other states in which they may be not members of the state bar. And so if you're going to be litigating with attorneys working remotely, you want to think through making sure that you're complying with the ethical obligations, practicing in that way. So first, we also have the ethical rule of confidentiality, Model Rule 1.6c, that we discussed earlier. We also have the unauthorized practice of law rule, which is ABA Model Rule 5.5a, and that provides that a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. And so for this one, I just want to give a few tips here. First, for attorneys that are working from home, you want to again make sure you're taking steps to ensure that the confidentiality and security of the documents your attorneys are accessing remotely is preserved. And one thing I just want to highlight here is that, I think that companies and clients gave that guidance at the beginning of the pandemic, or should have given some guidance in that respect, but it's probably time to revisit and make sure that that guidance is still current as we move into the hybrid or remote context, so that people are continuing to take the steps they need in order to make sure that the information is secure, and as secure as it can be from cyber criminals. Secondly, you want to ensure that the security and confidentiality for virtual meetings like Zooms and Teams. And I raise this because, again, my expectation would be going forward, when lawyers are not taking reasonable steps to preserve the confidentiality of these discussions, that could potentially implicate privilege and confidentiality, and could potentially risk your client's information being made public or being turned over when it's not supposed to. And that applies both in the home setting to make sure that you have a space in your house where you're able to take those meetings securely, but also making sure that you're using passwords, other things that are making it difficult for people who may be surreptitiously trying to get into your meeting to do so. And third, and this is something that it depends on what you have in your home, but you should take steps to disable the listening function on smart devices. And that's, for example, things like Siri, Alexa, Google Home. And that's because the technology of those typically works in a sort of all listening mode, where they're always on in listening mode. And so if you're at your house or you're discussing confidential information, Siri is potentially recording that, and that could constitute an unauthorized disclosure of the information to a third party that could, just unwittingly, just by having those devices on at your home. Now, I understand if you have Alexa or Google Home, if you disable that function, that may also undermine the functionality of the device as a whole. But as lawyers, I think we need to make the steps we need to take in order to preserve confidentiality, and having those functions on our devices is not very, very consistent with doing so. And then if you're relocating to another state, the ABA issued a formal opinion during the pandemic on this, and the general guidance from the ABA is that if you're basically doing the same job, but you happen to be in a different state, that the general rule is that doesn't by itself mean that you're engaging in the unauthorized practice of law. However, there are some aspects of that you want to make sure you're not doing that might cause you to actually slip into the world of unauthorized practice of law when you're not intending to. So first, you need to look to guidance from the bar of the new state that you moved to. So certain states like Maine and Utah have issued opinions on this. Other states may be considering issuing similar opinions like that going forward. But if there's specific guidance on the issue from the bar of the state where you now live, you should look to that and follow that guidance. If there's not that guidance, there's some things that the ABA has pointed out that you should avoid doing as well. So you should avoid establishing a business office in the new state. And that may be obvious if you're working from home, you might not think about establishing a business office there. But you should also not put a local address on letterhead, business cards, websites, or other indicia of a lawyer's presence. So you want to make sure that even though you've moved to the new state, that basically you're not making widely known to the world that now you're in that state in your official correspondence that you have for your law firm. And then also, you shouldn't practice the law of the local jurisdiction unless, obviously, if you have pro hoc vice privileges, but absent that, you shouldn't practice that law, nor should you hold yourself out as available to do so. And so again, I think the upshot there is, if you're moving to a new state, you need to look to see if there's specific guidance that would apply to you based on the state where you're going. But it's just, it's not just simply that because you've moved that you now have to take a new state bar. It's generally, I don't think that's going to be the case, but you just need to make sure if there's specific guidance that you're following it, and that you're not doing things that are signaling to the new state in which you live that you're open for practicing in that new jurisdiction. So if for those who may be interested, there's some other resources, 3 formal opinions that are issued by the ABA in the last 4 years that go to this, and there's been some cases that have issued involving these issues. But I guess with that, I don't know if there's any Q&A that anyone has or any questions people would have about some of these issues.